Welcome, everybody. Before we go on the let's make sure everyone's here. Looks like it. Before we go on the record, just a couple of housekeeping items. Make sure your cell phones are silenced, and be reminded that we are on a live stream. We'll get to that in just a second. Welcome to the Office of Tax Appeals. My name is Judge Turner. This is the hearing for the appeal of Hansen. This is being recorded and live streamed via the Office of Tax Appeals YouTube channel, and a copy of the recording will be available there. So be sure in your presentation you don't disclose any personally identifying information, social security numbers, telephones, that sort of thing. Just recognizing that this recording will be available on YouTube and is being live streamed. We are transcribing this hearing electronically. So that record will be available to the parties on our website, I think within 30 days. But be sure when you're providing a presentation to speak clearly. We want to make sure that we get a clean record, make sure you avoid speaking over other people clearly and loudly. And if we need to interrupt you at some point, either to slow down or speed up, we'll let you know. Just be prepared. And then, like I said, the transcript will be available on our website. A reminder, OTA is not a court. We are an administrative agency. We are staffed with subject matter experts, but we're independent of the taxing agencies. And my role as lead judge, I'm joined today by Judge Elsom and Judge Brown. My role here today is simply to conduct the hearing, make sure that we get a proper record, and that the hearing itself is orderly. When it's your opportunity, wait for your time to speak. Make sure we don't speak over one another. I will avoid interrupting unless I have to, but that's a possibility. So just be aware of that. And any questions before we proceed on the record?
Nope.
Okay. Then I will ready to proceed. We are going on the record. This is the appeal of Hansen, OTA case numbers 241118126. The date's January 13th. The time is approximately 10:32 a.m. The hearing is being held electronically with the agreement of the parties. As I mentioned, I'm Judge Turner. I'm the lead for purposes of conducting the hearing. My co-panelists, Judge Elsom and Judge Brown. We are all equal participants in the deliberation of the proceeding, and in the determination of the outcome of the appeals. If I could ask the parties to introduce one another, starting with Mr. Hansen.
Yeah, my name's Tyler Hansen.
Welcome. Respondent.
Arthi Ramalingam and Noel Garcia Rosenblum for Franchise Tax Board.
Welcome. Thank you. As stated in the minutes and orders that came out, the issue today is whether appellant's claim for refund is barred by the statute of limitations. Does everyone acknowledge that's the issue for today?
Yes.
Yes.
Perfect. I have his exhibits. Appellant submitted a single exhibit. We'll call it Exhibit 1. Respondent.
Sorry, could you start again?
Sorry about that. Respondent submitted exhibits A and B. There were no objections with respect to these exhibits being placed in the evidence. Is there any objection at this time before I admit those records into evidence?
No objections.
And those exhibits will be entered into evidence. Witnesses. My understanding is that neither party will be intending to provide witnesses today. Does that remain true?
Correct.
Correct.
Perfect. All right. Then with that, we begin with the appellant's presentation. And as I understand, at the pre-hearing conference, it was agreed that appellant would get 10 minutes, respondent would get 10 minutes, and then appellant would follow up with 5 minutes to reply if they chose to. You're aware, the panel may ask questions after a presentation is complete, but not always. So just be aware of that. We'll go through that as we come. So with that, Mr. Hansen, I leave it to you for your 10 minutes of presentation.
Okay, thank you so much, and good morning, everybody. This, in my mind, this case really is about overpayment of California taxes that was held at the sale of my house, and those taxes that were never owed. And I acted in good faith, complied with all the laws, everything at the time. The only reason my refund really was filed late was because the Franchise Tax Board sent a notice to an incorrect address that I don't have any affiliation. So I never actually received notice that the refund existed or that deadline was coming due. Once I became aware of the issue, I acted quickly, tried to understand what had happened, filed through that original licensed tax professional who did my Utah taxes. And the state suffered no prejudice, and and denying the refund would result in, the state really retaining money that was never entitled to keep. I just respectfully ask that the court apply equity and grant the refund. This really was my first ability to sell a home. It was my first home that I bought. At the time when I sold the home, young family, had one child, had recently lost my job, and financially I had every motivation to file for this had I have known that this was, something. At the time of the house, or at the time of the sale, I was living in Utah, and Utah is not a state nor that requires these pre-tax withholdings. And so the tax professional who I went through here in Utah, who filed all my taxes, obviously looked at everything and thought everything was good and moved forward. There was no attempt to avoid taxes, or, the state already had the money. So the total amount was $11,522. Again, as I mentioned, I had every motivation, was financially in a really hard spot, young family, needed to sell this house to basically make ends meet at that point. So what ended up happening is that there was a letter that was sent to an address that I have no affiliation with, never lived there. It's 2 or 3 cities away. And that letter was sent in February. And the letter, by the grace of God, in my opinion, it got to me second week of August, which was already outside of the window. And so when I received that letter, I acted quickly, again, reached out to that that filed the taxes in 2019, asked what happened, what could we do, and started to start the process there. So here we are 18 months or so into that process. And so that's really kind of what happened. As soon as I learned of the issue, again, I acted promptly, engaged the licensed tax, board. And as I mentioned previously, I think there's only 1 of 5 states in the nation that requires these pre-withholding taxes. And again, this was my first sell of any type of house. Really, granting the refund doesn't harm the state's interest at all. The funds were never lawfully owed, and they acknowledged that it was an overpayment. And so I respectfully ask the court just to apply equity, where strict application of the deadline would result in unjust enrichment to the state. And the purpose of the statute is finale. It's not to penalize the taxpayers, who overpay in taxes and were deprived of that notice. So really, in closing, I paid what I owed. I acted in good faith. I missed the deadline because I was never really informed, whether that be because the tax board or, my accountant. And I'm simply asking for a return of money that was never owed. I'm not asking for, a new rule or anything, only to apply equity where the notice was failed. And I paid what was required at the time. And the state already had the money, and I missed the deadline solely because I was never informed, and that was sent to the wrong address. And so I just respectfully ask that the refund be granted for money that was never owed to the state. So that's what I have.
Thank you, sir. You filed it's a Form 563, is that right? The withholding, the statement, a real estate withholding statement, is that right?
I believe so.
I was just curious what the address on that was.
the five, let me look and see. $563. So is that a document that I would have been
Oh,
filed?
593. I'm sorry, 593. I
590,
apologize.
okay.
Yeah.
I
Can't
had
read my
to,
own writing sometimes.
yeah, I had to send that in 593. I had to send that into the tax board, and so I have a really unlegible
That's fine.
one. But in 2019, I would have been at my current address. I've been there since 2016, and I'm still there. So that's the only
Got it.
address I would have ever put on. So that for sure
Understood.
put on there.
Okay. Thank you. Respondent, 10 minutes. You got 10 minutes for your presentation. Thank you.
Mhm. Good morning. My name is
Good morning.
Arthi Purmalingam, and I, along with my co-counsel, Noelle Garcia Rosenblum, represent Franchise Tax Board in this matter. At issue is whether appellants filed a timely claim for refund for the 2019 tax year prior to the expiration of the statute of limitations. In February 2024, respondents sent appellants a letter explaining they had unclaimed non-wage withholding credits for the 2019 tax year, but there was no California income tax return on file for their account. In October 2024, appellants filed their 2019 return, which serves as their claim for refund. Since the return was filed 6 months after the expiration of the statute of limitations, respondent is barred from refunding or crediting the overpayment. California law provides that a claim for refund must be filed within a specified time period known as the statute of limitations. As applicable here, the statute of limitations provide that the last day to file a claim for refund is the later of 4 years from the due date of the return without regard to extension, or 1 year from the date of the overpayment. In this case, the original due date for appellant's 2019 California tax return was April 15th, 2020. The 4-year statute of limitations expired on April 15th, 2024. Appellant's claim for refund was filed on October 14th, 2024, which is 6 months past the 4-year deadline. A claim for refund is also timely if it is filed within 1 year of the date of overpayment. The law states that the withholding credits are deemed paid on the due date of the return. In this case, appellant's withholding credit is treated as paid as of April 15th, 2020, the due date of the 2019 tax return. As such, they did not make any payments within 1 year of their claim for refund. Therefore, the 1-year statute of limitations is also unavailable to allow a refund to appellants for the tax years in consideration by this panel. It is well settled that the language of the statute of limitations is explicit and must be strictly construed. The United States Supreme Court in United States versus Dom explained that this is true, even when it is later shown that the tax was not owed in the first place. Appellants contend that their refund should be allowed because they did not receive notice of their unclaimed non-wage withholding. However, not receiving the notice of non-wage withholding does not change the appellant's responsibility to timely file a return and will not extend the statute of limitations. It is well settled that the Franchise Tax Board is not obligated to inform a taxpayer of the time within which a claim must be filed, and that the Franchise Tax Board has no duty to discover overpayments by taxpayers or notify taxpayers of overpayments. While this can be a harsh result, any perceived unfairness is redeemed by the clarity of the legal obligation imparted by the clear deadlines to file a claim for refund. And the Franchise Tax Board is legally obligated to apply such deadlines. Accordingly, appellants have not provided any additional evidence that would allow the Franchise Tax Board by law to grant their claims for refund. Therefore, respondent respectfully requests that the Office of Tax Appeal sustain Franchise Tax Board's claim for refund denial for the 2019 tax year. Thank you, and I'm happy to answer any questions you may have.
Thank you. I will go to my panel members before we get to Mr. Hansen's closing remarks. I'll go to my panel and see if they have any questions for either party.
I did have one question for appellant, Mr. Hansen. So the Franchise Tax Board did provide that Form 593, and it's not completely legible, but it looks like you did sign it. And it was appears to be April 2nd, 2019. So I just wanted to ask you if you're aware of what the purpose of that form was, and if you remember completing that form, or if that was prepared by your tax preparer. And then also, did you review your escrow statement to see that any amount was withheld on the sale? So just if you could just provide some insight onto those two questions.
Yeah. So to talk about the 593, that was prepared by my tax. I don't do this every day, and it's really hard you get a packet with 100 pieces of paper in there, and taken through on the withholding at the time of the sale. I don't remember anybody explaining those withholdings. The sale was done by a California real estate agent, and so it would have been, she probably would have been aware of it. It was just her second, but nothing that I had done. Again, that was my first one being in Utah. That wasn't a thing in Utah, because I also had a friend who was a real estate agent over here, just kind of walking me through, what I need to do, and it was never mentioned. So, but yeah, that 593 would have been prepared by. Is that something you sign at the sale of the house, or is that something you submit after the fact? I guess
I believe it's required after the sale, during the tax year. But I just wanted to get some insight as to what your understanding was at the time. So I appreciate the response.
Yeah.
And have no questions for respondent from me. Thank you.
Judge Brown?
I don't think I have any questions at this time. Thank you.
Yeah. Mr. Hansen, that returns to you. 5 minutes for any closing remarks.
I mean, I really don't have much. I mean, I'm not a professional in this area. Like, these are, it just would have made all the difference in the world to my family and myself back then. And, I just think at the end of the day that paying taxes, I've never missed taxes. I've never been late on taxes. I've always been, there and on time and fair. And I just feel like if it's money owed, it's money owed, right? And I think in each of our personal life, if we would have given money to anybody and they would have come back and said, "Hey, you actually didn't know this money," I can't see a world where in our personal lives we would think, "Hey, there's a time frame, and hey, you didn't know about it, but we're going to cut this off." And so at the end of the day, I just think doing the fair thing, the right thing, is to take care of the taxpayers, right? At the end of the day. So thank you so much for your time and whatever you guys decide.
Thank you. Really appreciate that. Finally, just make sure we'll circle back and make sure there are any last questions by anybody on the panel, any of the panel members. Judge Elsom or Judge Brown, any questions?
No questions from me. Thank you. Thank you for your presentation, Mr. Hansen.
Questions of either party as well. Respondent, do you have any questions of appellant or vice versa? Appellant, respondent.
Respondent has no questions of appellant. Thank you.
No questions.
Great. Okay. So with that, the case is submitted. This is on January 13th, 2026, and the record is now closed. Thanks everyone for participating today. The judges, we will meet afterwards to deliberate and decide the case. We will issue a written opinion within 100 days. Today's hearing on the appeal of Hansen is now concluded. OTA will remain in recess until 1 p.m. when our next hearing starts. Thank you all for participating today.
Thank you.
Thank you. So next steps, I'll get an email.
You'll get a notice of our decision. You'll get a notice by email with the decision.
Okay, perfect. Thank you
Thanks
guys
so
so
Within
much for your
100
time.
days.
With about 100 days. Okay, perfect.
Yeah.
Thank you guys so much. I appreciate this.
Thanks for your time.